Especially
You
fresh
can
chicken.
eat carbs, you can eat sugar or and carbs. Keto, the keto diet's absence of sugar and or carbs.
Yeah.
Like all sugars too.
Well, it's like I think it's like 0 sugars and then like very low carbs. I mean,
I did
it's
zero.
zero.
Zero. However, I did 0 carbs, but I did eat fruit sometimes. Like sugar and fruit.
Actually, it is just the protein base.
Yeah, he's
It's
not.
like edamame, the yogurt, veggie patties, cheese, and and I'm missing something. I just don't remember what it is. But the other one, I think it's
What's
like
it talking about?
like chicken, veggie, and then like a couple like strawberries.
Is it next one?
Yeah. Fourth year, how,
Well, good luck.
At least here
all
and
four years.
start up somewhere.
Yeah.
First year, yeah.
I think so. Yeah, because there's so much pressure.
Yeah.
I'm not, I'm waiting for the pressure other than trying to get you act together. Which has paper. And then it's, and then after that it's.
Yeah.
So I found out because we insured that bar
Yeah.
that had the shooting. We had canceled them for non-payment the day before the shooting. They paid their premium differential, and I was like, oh my God.
Oh.
Cause all these claims started flooding in and they didn't know, do we deny it because of lack of insurance or what? And I thought, oh, the judge is gonna make us pick it up, you know. 'cause-
We're California, they're gonna make you.
I know, and we're insurance and we have the money, so I go, they're gonna make us pick it up. But the day before, he paid.
Mr.
he was-
Drucker isn't gonna be here today and post some charts somewhere.
So the 10-minute rule applies? No, I'm kidding.
She's here.
Oh, cool, thank you.
Oh. So it was
It's almost like the fraud case we had, except there's no way that this was fraud.
I know, and we were like, what do we do based on lack of insurance? I think then we look bad because it's gonna be
Yeah,
all over
you're
the news that we had. no
Yeah,
insurance.
It was
but-
a heartless.
I know,
Hello.
so, we were just holding on to cases like, what do we do? Cause what happened, I guess the cashier got shot and one of the
She was
security.
20 years old.
20, yeah, was she 20?
Yeah.
Somebody else has her kid. And then there was a security guard.
Yeah,
who
he was like
had all
33.
these psych claims coming in.
Oh, I'm sure.
Oh. She's saying that, you know, shooting with the couple, that they had canceled their like insurance, because they lacked a payment, they paid for the shooting, they paid a premium. And now they have a bunch of like cases. And they don't know where to
Wait,
go.
we'll pay premium.
The bar
Like the
in,
day
Van
before,
Nuys.
and they weren't sure whether to like.
Cause it wasn't, you know, the people that were getting the money, the premium, the policy section of it, they weren't inputting the stuff fast enough, so we were getting claims like, do we deny it or do we just look bad if we deny it? You know, cause it's like, it's all over the media.
Is you just falling the wall? I gotta hold on to, it's not your fault today. So.
The owner wasn't covered, but all the other people
The other one's covered.
were. No, but we have a lot of site claims coming in.
Yeah.
so-
Man, yeah, I can imagine.
Yeah.
Apologize, I just realized I left my handouts in the office. I'll go grab those. Very fast, thank you.
I know you need some caffeine. In the coop.
Yeah.
Okay. Why?
I'm just tired.
With an espresso shot.
That's what I need. I should have got a coffee.
There you go.
Thank you.
Ooh, almost flung out there. There you go, there you go. So, got a little crossover here with tort, huh? All right. I spent several minutes looking for my outline, which I had conveniently put in my book, so I didn't see it when I was looking in all my other documents. So my apologies. Okay. So, little recap on last week. Concurrent estates, right? How many do we have? How many do we have?
There's 4.
What are they?
Joint tenancy, tenants in common, tenants in sufferance, and
Tenant in entirety?
Tenancy in the entirety. I don't know that I would say a tenant in sufferance is necessarily a different type of tenancy, but okay. I'll give you that one. So, which one is allowable only for spouses?
Tenancy by entirety.
Tenancy by the entirety, right? So we say spouses now. Previously, it would have been husband and wife, and now obviously the law has changed. So it is married persons, right? So in that case, there is a right of survivorship. And in some states, it's kind of presumed if it is a married couple making the conveyance or receiving the conveyance. However, does California follow tenancy by the entirety? 50-50 chance on this one. Nope. Why?
You do community property.
Because we have community property laws, so we don't really need that because it's probably going to the other person anyway. And there's special rules about community property in California. For purposes of joint tenancy, what distinguishes a joint tenancy from a tenancy in common?
the right of survivorship.
The right of survivorship, right? Is that automatic just because you say it's a joint tenancy? No, put the language in there, right? Joint tenancy with right of survivorship. Put it in there. Dumb it down. Don't make any questions about it, okay? What happens? Well, let me back up. What else must you have in a conveyance for a joint tenancy with right of survivorship?
The 4 unities.
The 4 unities, right? Same title, same time, same interest, and right to possess the whole, right? So T-tip or Pitt, whichever you want to, now I always like to say, you know, I'd be happy to live with Brad Pitt, but I don't know, everybody's got their issues. So, must have the 4 unities present in order for that to be a valid joint tenancy with right of survivorship conveyance. We talked about how a joint tenancy can be severed. It can be severed by a sale by one party. It can be severed by a mortgage on the property. And then we talked about title versus lien theory. I'd say more often than not, you will find that there's at least one multi-state on that question, and it has been known to creep into a written exam before, okay? So understand the distinction between title and lien theory. One is going to be causing a severance of the joint tenancy. The other is just going to be a lien against the property's interest, okay? The other one that I love is partition, right? So we've got a partition in kind. That was, you put the tape down the middle, half is yours, half is mine, right? Chances are you're seeing this with a larger property. It's not going to be on a 1/4 acre that you're severing it, because it's going to be difficult to do anything with 1/8 of an acre, right? Now, that being said, for sale is the other type of partition. What they do there is they actually take it to court. The court makes a determination that it's in everyone's best interest to sell the property and then divide the proceeds, right? So it's more of a financial circumstance. Now, in cases where you might have large acreage and this is perhaps like a family-owned piece of land for years and years and years, and then the now children of the deceased parents are fighting like cats and dogs, and they can't get along, they either need to shape up so that their family property doesn't get sold, divided, or they're going to lose their family legacy there and then end up with some amount of money. Now, some of the siblings might say, hey, I don't want to be on the property, I don't want to have the property, I just want the money. And they might say, look, if we can't agree on what we're going to do here, then maybe the forced sale is better. And then everybody can go their own separate way. Now, this is not the value of the property sentimental value. So you also have to look at that. If you're advising somebody, look, I realize this is a very important piece of property to you, but here's the fair market value of the land. And you will get your X portion of the property. It may not be very lucrative for them to do that. But if they want to be separate, they want to be separate. So I suppose you could buy it out. One party could buy it from the others, but then you have to come up with funds to do that, right? As a practical matter, that might be something if it was a sentimental piece of property. Okay. For purposes of severance, the other thing I want to point out with the joint tenancy is that if you sever a joint tenancy, does that automatically sever the entire joint tenancy? No, right? What does it sever? That particular interest holder, right? So if there are 3 parties, A, B, and C, each have an undivided third interest in it, and then A sells their interest to D, now D is a tenant in common, B and C are still joint tenants with right of survivorship. So if something happens to C, so if something happens to Charlie, everything is going to Bonnie from Charlie's portion, right? So it's important to know that, because what if Charlie's son thinks he's getting dad's interest? He's going to have a rude awakening because there's a right of survivorship there. Now, if David, that's the D, right? He's purchased from A, and he now has a tenancy in common. If he dies, his property is going to his son, right? It's not going to go to Bonnie and Charlie. Make sense? You want me to draw that?
So if A dies, okay, wait a minute.
Let's look at it here. Okay, we've got A, B, C, okay? Joint tenants with right of survivorship, okay? A sells to E. All right, I'm sorry, that was to D. That's ugly. Okay, A sells to D. This now severs the joint tenancy, okay? So now the joint tenancy with right of survivorship is only between B and C. So my comment was related to if Charlie dies and he has, let's call him Edward, okay? Edward is Charlie's son, okay? Edward believes I'm just become a land baron, right? I'm just gonna inherit dad's piece of this property. And turns out not so much, because this is now gonna go over to B. B is now going to own 2/3, right? Different from if D passes away, because now this is just this is now a tenant in common. If D dies, I guess we have to use an F, so D's son, Frank, right, would inherit, right? It doesn't go over to B and C because there's no right of survivorship anymore. Make sense?
So if C dies, everything goes to B, nothing goes to D?
Well, let me ask you this. This is a little trick I like to use that my professor used to use with me. Tell me why it all goes to B.
Because those two are joint tenants. But
And?
the other one is.
No,
Okay.
don't go there yet. They're joint tenants with what?
Right of survivorship.
Right, so when one dies, it goes to the other,
Okay.
right? Now, in this case, they've severed the joint tenancy with right of survivorship as to A, because A sold to D.
Right.
So now tell me why D's portion would not go to B and C if he dies. What is D now?
Well, D is a tenant in common.
And does a tenant in common come with a right of survivorship?
Oh, that's.
Right.
Okay.
Okay, so now, I like where your head's at here. So let's try this, a little bit different. Does it help to review what we talked about last week a little bit?
It does.
Okay. I know it's all absorbing when we do it during the week, so. Oh, this spelling, sorry. It's a little OCD there. Undiagnosed, but I know it's there. Okay. Okay, now. Ooh, okay, well, that worked. Okay, A, B, and C, joint tenants with right of survivorship. C kicks the bucket, right? Now what? What interest do A and B have?
Half.
They each have a half interest now, right? They went from 1/3 to a half. Make sense?
Mm-hmm.
Okay, all right. Easy peasy. Who's hoping for a joint tenancy?
And
Yeah, no.
With no tenants in common.
Oh, I wouldn't be that nice. I'm a very nice person, but I'm just not that willing to do this. Yes, ma'am.
What if can a joint tenant convey their portion without knowledge of the other one? Yeah, so we did an essay this weekend. I think that threw me off.
A joint tenant can, you mean, can I just sell or convey it to somebody else?
If it's
Yes.
just two.
Yeah, and it creates a tenancy in common.
Okay.
But I think maybe where you're getting a little confused is in a tenancy by the entirety, one party, because there's a right of survivorship, but it's very special because it's a husband and wife or a husband and husband or wife and wife or whatever other variation we have, they cannot independently or unilaterally convey, because the example I gave was, daddy wants to give his daughter, daddy's little girl, right, his half of the property. But evil stepmonster doesn't want him to do that, so he just conveys it. And then when he dies, daddy's little girl is thinking, great, I now own half. Ugh, it's with the evil stepmonster. And evil stepmonster says, I'm sure your daddy loved you a lot, but he couldn't do that without my permission, and I didn't agree to it. So the right of survivorship is still there, it all goes to stepmom.
That's entirety.
That's entirety.
Okay.
Yeah. So I understand where that can get a little confusing. It looks the same, but you have to categorize it as between spouses. That's where you cannot unilaterally do that. You also should not be unilaterally mortgaging the property or creating any encumbrance on the property without the other party. And then at that point, you shouldn't be able to get at the other person's asset or financial holding as a result of one party's unilateral lien or mortgage. Okay. I'm not gonna go necessarily through all the rights and duties, but we know what they are, right? And then we also understand the concept of an ouster. Okay,
Yeah.
all right. So, that being said, let's get into this week's material. What page are we starting on?
517.
That was close, that was one page off. All right. Uh-oh, what happens when somebody gets hurt, right? All right, so a little premises liability, right? Remember that? Okay. Now, who wants to do Walls versus Oxford Management Company? So don't jump at once.
I'll try.
Yes, ma'am.
Okay. So, I had the facts as on December 5th, 1988, the plaintiff, Deanna Walls, was sexually assaulted in her vehicle, which was parked on the premises of the Bay Ridge apartment complex. Plaintiff lived with her mom, who leased an apartment there, and Gerald Buckley was arrested and convicted of sexual assault. Bay Ridge is owned by defendant Nasha, Oxford Bay Association, limited partnership, and managed by defendant Oxford Management Company. So for the last 2 years, a number of crimes have been reported, and they were aware of this. The plaintiff brought action in federal court alleging that defendant breached their duty as a landlord. So I had here as whether the implied warranty of habitability imposes an obligation upon a landlord to prevent a criminal attack on the tenant. So reading it, I kind of put a little bit of things in there. I put that at one time landlords had immunity from simple rules of reasonable conduct, which govern other persons in their daily activities. But in Sargent versus Ross, a landlord owed no general duty to his tenants and could be found liable for injuries caused by a defective or dangerous condition on leased property. So, they were showing on Sargent, about the general duties, something about hidden danger in the premises of which the landlord, but not the tenant, was aware. Premises leased for public use and premises retained under landlord's control, such as common stairwells, or premises negligently repaired by the landlord. So, so I put down, yeah. So in Sargent, however, this court abolished landlord immunity and held that a landlord has a duty to act as a reasonable person under all the circumstances. So there were two questions asked with the court, and one was, first question was the common law rule that private citizens ordinarily have no duty to protect others from criminal attacks. So they put that we hold that a landlord who undertakes either gratuitously or by contract to provide security will thereafter have a duty to act with reasonable care. However, a landlord has made no attempt to provide security and is not responsible for a physical defect that enhances a risk of crime. So the court doesn't find such duty. And the second question is, do we hold that the warranty of habitability implied in residential lease agreements protects tenants against structural defects, but does not require landlords to take affirmative measures to provide security against criminal attacks?
Okay.
So they were talking about the housing codes and breach of warranty, and so it kind of got into, well, like we said, into the tort action part of it, of the landlord. And
Mhm.
so it ended up, it was remanded. It said that the holding, a landlord has violated an express agreement. Okay, wait a minute. This holding is no way limits a tenant's recovery when a landlord has violated an express agreement to provide security measures or has invited such an attack through a violation of an express housing code requirement.
Fair enough, is that what we have here?
Yeah.
Is it?
So,
Who agrees? Who disagrees?
What was the question?
Sorry, I was reading my next brief. Just kidding. I don't, oh wait, I just got it. She fell asleep. She didn't hear the question. Oh my god, I had totally forgotten until you did that. I'm no joke, I had totally forgotten about it. Oh god, I just got so excited. Oh my gosh, my day just got so much better. Okay, so we're all awake now. Share some of that coffee with her next time. Okay. Oh my god, I'm so excited. I'm gonna try and take it easy on you. That would be fun. Okay. They are very specific in this case. The holding, meaning there was a perhaps different position that they took, because they're saying if there was a circumstance, so the fact that they're saying this holding in no way limits a tenant's recovery when a landlord has violated an express agreement, doesn't that imply that the holding is opposite from this particular exception? So wouldn't that mean that it does not fit into this category?
Okay.
Okay, sometimes we just have to step back and look at it and say, okay, if they're saying, but you could still sue for this if something like this happened, and it's contrary to the holding in this case,
Okay.
then we have to know that there was not a circumstance where there had been some specific express agreement to security measures, or that such an attack occurred through a violation of an express housing code requirement.
Okay. So
You weren't gonna find one.
Okay, so that's why they remanded it and sent it out.
Well, they sent it back because they said, we don't find that those arguments are sound.
Okay.
So let's look at this a little bit. Let's piece it apart a little bit. You can sit down. So let's go back to the beginning, right? I know you're trying not to laugh now. I know. She's like, oh dear God, she remembered. Yep. So now, I don't know that I necessarily want to live in Bay Ridge Complex with, in the 2 years prior, there are how many? Was it 31?
Yeah, 31 incidents.
31 incidents of criminal activity. Now, okay, that sounds bad on its face, but let's take a step back. Could that mean that there were trespasses, minor thefts, other things, right? Because we're talking in this case about like a forcible sexual assault, right? Okay, so let's break it down now. We've got 11 automobile thefts, 3 attempted automobile thefts, 31 incidents involving criminal mischief or theft, no sexual assaults or similar attacks against persons had ever been reported. Now, I suppose arguably you'd go back and say attempted automobile thefts. Were those potential carjackings where there were actually people there? Or was it the security light turned on so the people got scared off and took off? I don't know. But it's a bit of a stretch to say somebody who's going to go steal a car, if they bump into somebody, is now going to sexually assault them. Generally speaking, people will just kind of flee at that point. Worst case scenario, they're probably going to beat up the person or knock them down or pistol whip them or whatever they're going to do, then take their car. They're probably not going to stop to sexually assault somebody if what they came for was the car, right? So, that being said, I'm landlord. I know that it's not the best neighborhood and there's some thefts going on, but who's committing those thefts? Third party, right? Do I have control over the third party? Well, I can do things to reasonably secure the facility. What is it that they thought would be reasonable to prevent a sexual assault from occurring by a third party?
Is it higher security?
Higher security, right? Well, for something that they didn't know was going to happen, and they go through different theories, right? One of which that I think is very important is the third exception, where they talk about the incident or the existence of overriding foreseeability. Out of 31 incidences of criminal conduct, how many of them were sexual assaults? How many of them were crimes against person? Possibly none, right? No sexual assault or any crime similar to a sexual assault, or any crime of violence against person that we can see from what they've listed. So is it reasonable that they would have tried to prevent such an act, or that they were on notice, or it was an overriding foreseeability? See, I kind of got more extreme, given the facts that we have here. No, right? So if you're having some thefts and some other things going on, what are you going to do maybe as a landlord? What's the easiest and fastest thing you could do? Well, I'm probably going to say, send a newsletter to all my client or all my tenants and say, hey, there have been some vehicle break-ins. Make sure that you park in areas that are well lit, that are in designated spots. Make sure you are confirming that you have locked your car, that you have, used some anti-theft device if you can. Get a club, get an alarm, do whatever you need to do. Those are the things you might do preliminarily. Notify your tenants. Tell them, hey, here are things you can do to make yourself less of a mark effectively, right? Then maybe they could install more lights. It's a more well-lit area. It's going to be harder for somebody to conceal themselves when they're trying to steal your car or commit a theft. Make sure your doors are locked. Make sure you're not leaving stuff out on your patio. Maybe people are coming in and kind of swiping stuff that are out there. Maybe you leave a radio out there and somebody came and stole your boombox, right? So, that being said, nowadays you probably just steal the speakers, right? Because nobody actually carries a full, just hook it up to your phone, right? Bluetooth.
This is in the 90s though.
Right, but I'm saying now, it's not gonna matter. So, I think about it from my house, and we've got speakers outside that sit on the table out there. Got some other ones in different parts of the house, but we just leave it out there because we stick the phone on it when we come out. Not unreasonable to maybe recommend that stuff be brought inside, right? Stuff that's easy to carry away, if there are thefts occurring, we need to take precaution for. So a second exception arises where there's a special temptation and opportunity for criminal misconduct brought about by the defendant will call upon him to take precautions against it. Was there anything that this landlord did that brought about a special temptation? No. This was deviant sexual conduct by a third party. Him having people reside on his property is not something that provides a special temptation to a third party. Not happening. There is no special relationship here either, right? This isn't a hotel. That might be a little bit different, right? An innkeeper relationship or a common carrier relationship. That's not what we have here. This is basically private residence for each one of these people, right? The fourth exception derives from a general tort principle that one who voluntarily assumes a duty thereafter has a duty to act with reasonable care. Did they assume any duty? No. In fact, they don't really have much of a duty. They have no duty to make safe. They were talking about here areas that landlords do have a duty, like with latent defects, right? Is this a latent defect? No, it's not. Now, if they tried to some way conceal criminal activity that had occurred there, perhaps we have a better argument. Now, they kind of flip it on its ear and start talking about the other way to approach this, which is an implied warranty of habitability. Do you guys remember when we talked about that? Implied warranty of habitability really related more to what?
Safety, like,
Well, like a quality of life, like basic human habitation needs, right?
sanitary.
Right, sanitary issues. So, do you have running water? Do you have heat? Do you have cockroaches all over your house? You know, is there an infestation? Are there zoning violations? That's not what we have here. We're dealing in a circumstance where, for all we know, it is perfectly up to code, and a third party came in and did this. You don't necessarily have an obligation to make safe. You have an obligation to meet the standard for basic human habitation. Basic human habitation does not require security, right? So they were not going to expand into that, and they basically went through that discussion. They started saying that an agreement to rent a property contains an implied warranty that the apartment is habitable and fit for living, that there are no latent defects on the facility, and that are vital to the use of the premises for residential purposes. It does not, however, expand into any liability or any dangerous circumstance that occurs on property, especially things that the landlord can't control. Even if they had security, could this still happen? Yes. And at what expense does the security come at? Probably pretty significant, right? Okay. So, at the end of the day, they basically say, we hold that the warranty of habitability implied in residential lease agreements protects tenants against structural defects, but does not require landlords to take affirmative measures to provide security against criminal attack. They then say, if this was slightly different and there was a circumstance where the landlord has violated an express agreement to provide security measures or invited such an attack, then you could still go after them for some breach. Okay? So, do you think that we have a better argument if there have been 2 prior sexual assaults on site and nothing changed? Let me give you this hypothetical. Lights have been busted, they don't come and fix them, even though they know, and they're in the same area where the 2 women had previously been sexually assaulted. The front gate's not working, the security gate is busted open, the walk-through gate's busted. There are a bunch of things, maybe the wall that goes around has been, the structure has been affected so people can get into that area and conceal themselves. Do all of those things now, or maybe the door at the front, maybe it's like an apartment complex and they have a security door at the front. Maybe that's not working. Do we now have a better argument for foreseeability? Yeah, absolutely. So you have to look at this as very factually driven. So it would be very easy to write an exam on that. I haven't written the exam yet, but sounds fun. Okay, so everybody get that one? All right. They basically touch on a bunch of stuff and say, well, maybe this way, maybe that way. Nah, none of these ways are present here. Okay. Now we get into the fun stuff, right? This is going to be stuff that you will see in real life. Lesser's remedies against a defaulting tenant. What are we saying there? That's a fancy way of saying tenant didn't pay their rent, probably, right? What can a landlord do? You have to just be covering somebody who's not paying you to rent your property? No, absolutely not. I don't have an obligation to carry their costs. But you also cannot engage in what? Two words.
Constructive eviction.
Maybe hyphen it. Self-help. You cannot engage in self-help and just lock the door, put a padlock on the door and not let the person come in. Right? So you have to go through the proper procedures of a formal eviction. Or you can categorize them as holdovers, right? Elect to have them continue paying rent, create a periodic tenancy. We start seeing all that stuff, right? Okay, so termination of a lease. Foundation Development Corporation versus Lomans Inc. Who's gonna take that one?
I'll do it.
Okay,
Alright, so in 1978, Lomans became the anchor tenant in the Lincoln View Plaza Shopping Center and entered a 20-year lease with Foundation's predecessor in interest. There was no provision in the lease agreement for a rental increase or percentage rental during the term of lease. There was an option for a renewal for 2 5-year terms and could expire the latest in 2008. So Loman was to use the lease space for a retail clothing store, which was part of a nationwide chain. There was a base lease rate plus fees for the common area maintenance, which ended up being $50,000 total in annual payments. I think it was $45,000 for the actual rent, and then $5,000 I think a year for the fees for the common area maintenance. The lease included a time is of the essence provision granting Foundation the right to terminate the lease if Loman failed to cure any breach of lease conditions within 10 days of receipt of notice. So after some disagreement about the amount of the common area charges due in a certain year, Foundation sent a demand letter on April 10th, 1987 to Lomans demanding payment within 10 days. So then Loman mailed the payment on April 25th, and then on April 28th, before Foundation received the payment, they filed suit for termination of the lease, eviction, and payment of the common area charges, and then a day later, they got the payment from Loman. And
so did they withdraw their request for eviction and?
No.
Yeah. Okay.
The trial court concluded that Loman's breach of the lease was immaterial and denied Foundation's claims. So Foundation appealed, and the Court of Appeals reversed the trial court's decision, saying that even if Loman's late payment was an immaterial breach, Loman's failure to meet the times of the essence provision in the lease amounted to a material breach that justified termination. So Loman's petitioning to the Supreme Court for review. So for my issue,
I like this case because they say there were 2 issues present, and then they put a number 1 and a number 2.
yeah, I just didn't want to really type it all out because it was a lot. So can a landlord terminate a lease when there is an immaterial breach if there is an express provision in the lease agreement allowing so? And for my rule, I got, it was on page 529, absent some express statement of legislative intent, the court is hesitant to believe that the legislature intended to permit termination of a lease if the breach is immaterial. In other words, a lease may not be forfeited for a trivial breach, even when the parties have specifically agreed that any breach causes termination of the lease. So the court talks about how landlord-tenant law is a combination of contract and real property law. The traditional common law placed its greatest emphasis on maintaining consistency in the association between landlord and tenant. For that reason, common law treated the leasehold as a conveyance of a real property interest. A breach of lease covenants could not provide grounds for eviction of the tenant, nor for the tenant to abate rent. Arizona statute modifies the common law by providing a landlord the right to evict the tenant for non-payment of rent or breach of lease conditions. So Foundation is, putting forth the argument that the terms of the subject lease should be construed more in accordance with contract principles, and that the express language of the governing statute deprives the court of discretion over enforcement of the lease terms. But the court says that they reject that argument, and that the legislature intended to completely divorce landlord-tenant law from the policy considerations underlying its traditions in property law. So they end up saying that a trivial breach doesn't raise the right of eviction or termination of a lease, and terminating or evicting then would be inequitable. So they vacate the opinion of the appellate court and affirm the trial court's judgment in the lien's favor.
Okay. So they basically almost give a summary of the entire holding, the last paragraph on 529 that carries over to 530. They basically say, look, these are more technical, or these are more involved leases because these are for commercial properties. There's going to be a lot of pieces to it, and they didn't intend for every technical violation to necessarily create a forfeiture. So they basically said, look, it was trivial, it wasn't anything that really negatively impacted anybody significantly, and the intention was not for that to be, you know, a forfeiture of their interest, right?
Right.
Okay. Very nice, thank you. And everybody get that? All right. Okay, so now we move on to eviction. Ooh, retaliatory eviction. Yeah. Sorry, I get a little excited about real property law. I know, it makes me bizarre.
I like this next case.
So, somebody tell me what a retaliatory eviction is. No, tell me what the rule is.
Of the case,
What is a retaliatory eviction?
or one that's done in retaliation for some, I don't know, incident or
What kind of incident?
incident that affects the lessor or the tenant.
I think you might have it backwards. So let me give you this. If the tenant lawfully reports the landlord for a housing code violation,
Oh, we did have that.
that's good. Landlord is barred from penalizing the tenant by doing what?
They can't evict them.
Or
Increasing their rent.
increasing their rent, harassing them, ending their lease, or any other reprisal, right? So now we've all kind of got an idea of what this is, right? Tenant basically says, hey, this is violating the housing code, calls that in, landlord gets PO'd because they just got narked off. By the way, I always love that people tell kids don't tattle. I don't like saying tattle, so I always tell my kids don't narc on your brother. And I think one of them said it at school and somebody was like, what? It's okay, don't worry about it. So, a little more colorful sometimes. So, in that circumstance, what you're saying is landlord can't then punish tenant for making a lawful notification of a housing code violation, right? That's basically what the concept is. So let's look at this example. Talk about Edwards versus Habib.
Okay, so in March of 1965, Ms. Yvonne Edwards, which is the plaintiff here, she rented on a month-to-month basis from defendant Nathan Habib. The plaintiff complained to the Department of License and Inspections, and when they inspected the building, they found more than 40 violations. The department ordered the defendant to correct them, and then shortly after, the defendant gave the plaintiff 30 days to vacate and obtain a default judgment of possession based on 45 DC Code sections 902 and 910. So the plaintiff argued about the constitutionality of the two codes in aiding the defendant, but the court said that they weren't going to address it because they felt that that was not the Congress's intent. And then, so for my issue, I have, can Mrs. Edwards raise retaliation as a defense against the landlord who terminated a month-to-month tenancy authorized by a DC code? What I have is my rule is on 533, is while the landlord may evict for any legal reason or for no reason at all, he is not, we hold, free to evict in retaliation of his tenant's report of housing code violations to the authorities.
What kind of housing code? Let me ask you, characterize the nature of her housing code violations notification.
Like when she called him and asked him to come down.
Right. She conveyed what? Well, let me ask you this, when they came down, were they accurate representations?
Well, yes, because they.
Were they truthful?
Yes,
Were they lawful?
yes,
Okay, go ahead. Do you think this would be different if she made a bunch of stuff up?
yes.
Okay,
As a matter of statutory construction and for reasons of public policy, such eviction cannot be permitted. What the court said was that if they were to permit such retaliatory evictions, it would frustrate the effectiveness of the housing code as a means of upgrading the quality of housing in Washington.
sorry, I didn't mean to yawn, it was not related to you at all. It's just been a long day.
It's okay, I understand.
Oh my god, I literally totally forgot about it. Okay.
They further said that they had to consider the social context of their decisions that they will have on operational effect.
As a public policy matter, what does it do if you're, as a landlord, able to retaliatory or evict somebody in retaliation?
Well, they said that it gives off the message that's telling them not to dare to be so bold.
Right? Don't report. Live in squalor. Live in a place that, you know, have slumlords. That's okay.
Live in filth.
Right. I mean, that's what they're basically saying.
Mm-hmm.
Don't come forward because you'll get booted. They don't want that.
Other things they considered was the cost of moving, the inequality of bargaining power between the landlord and tenant, just what we touched on, and the social and economic importance to maintain a minimum standard of housing conditions. So the case was reversed and remanded.
So we've got tenant who makes a lawful notification to some housing authority, right?
Mhm.
And then they come out and they actually find like a grip of housing violations, right? So now we know it was lawful, truthful, accurate, right? So you want to really like, in these kind of cases, when you're doing an exam on something like this, you are going to make this poor, sad person who's just trying to make sure that they make a nice home, and this nasty slumlord landlord that is just making them live in filth and squalor, right? Okay. Depends on who you're arguing for. Okay. But if you're arguing for the tenant and there's a retaliatory eviction argument, then that's what you're basically going to be characterizing them as. So you can say, don't get too comfortable. I don't know how much shit those things. So I know it's gonna get old, but it still just makes me giggle. All right. So that being said, let me ask you, does that mean that the landlord can never, ever increase that person's rent? No. Do you think it's recommended during about a 90-day window after this happens?
No.
No, we usually say no for that. Do you think at 92 days you're in the clear? Probably not advisable, right? Now, let me ask you, what if on January 1 of every year of that person's lease, their prior contract indicates it's going to go up by 5%? Can you do that?
Yes.
Yes. Now, be careful around that 90-day time frame, but I think you can still arguably say, hey, it's what's been happening for the last several years, and it's in the contract. It was something that existed before we had this disagreement, and so now we're doing this. Now, if all of a sudden, you know, they go to try and evict them because they're one day late on their rent, and this is a month after this happened, do you think that they're going to still make an argument for retaliatory eviction? Yes. You are just nitpicking me because you know that I brought the police or the housing code here, and it cost you tens of thousands of dollars to remedy all of the housing code violations. You're just upsetting me, right? Or now every time I leave my trash can on the side of my condo for, you know, overnight, instead of getting it back in the house at the end of the day, you're sending me notifications that I'm in violation of the development's rules. But you never did that before. Now you're nitpicking everything I have. Oh, my car was parked for 2 hours and 10 minutes instead of 2 hours. Oh, you know, this other stuff was happening, and they start nitpicking and they start harassing you about that. You can use that as well. Now, chances are, if they're getting really nasty with you, you almost don't want to live there, right? But that being said, it may be a circumstance where somebody cannot afford to leave. Or they're, I don't know, I've heard of all kinds of examples. Maybe the people don't want to move because that's the only affordable housing that they can find in that school district for their kids. Or it's adjacent to their workplace, right? So there's a lot of reasons why somebody might stick around in the same place, even though they're not particularly keen on the management, okay? All right, thank you very much. All right, we're trucking along here. Okay, damages. United States National Bank of Oregon versus Homeland Inc.
I'll try that one.
Yes, sir.
Okay. So the defense here is Homeland Inc. And they leased office space from they leased office space from Ralph and Bernie Schlesinger, so they're being referred here as lessors. And it was a period 5-year term from April 1st, 1971 to March 31st, 1976. The majority of payments being in for $1,415 per month. Homeland vacated the premises on July 31st, 1973, with about 32 months remaining on the lease, and thereafter paid no more rent. The lessors weren't able to lease the property until Sebastian's came along in starting February 1st, 1974, and ending in January 31st, 1977. So the term extended the lease 10 months longer, and the rent was $85 higher, which came out to be $1,500 per month. And so just like Homeland, Sebastian's defaulted and vacated the premises on July 14th, 1974, and only paid about $7,500 in rent. So the lessor again wasn't able to lease the premises until about August 1st, 1975. So the lessor sued Homeland for the period of August 1st, 1973 through July 31st, 1975, which is 24 months at a monthly rate of $1,415 minus what Sebastian's paid, which is $7,500. So their net claim came out to be $26,460. Homeland then requested the court to limit the claim to the period from the date they vacated until February 1st, 1974, which is when Sebastian's lease began. The trial court granted the request and the court appeals affirmed. So, excuse me. I think there were 2 issues here. However, I tried to just put it into one. Hopefully it came out right. So there's a tenant's obligation to pay rent and or continue after the lease term, even when the premises are rented for a longer period of time to a second tenant at a higher rental rate, including a portion of the original lease term.
And when you say, okay, so let's do a timeline, a little bit, okay?
Yes.
This can be a general timeline, so we don't have to worry about those dates. Well, answer the question first.
Yeah.
Give me the holding.
Well, they said. Well, the holding is states that the lessee is responsible for the lease term despite another tenant.
They're responsible for the lease term, not forever, right?
Right.
Okay, so tenant, they lease for a period of 12 months, right? Okay, you can sit and relax. Okay, so tenant leases for a term, that's ugly. Oh, okay. Let's try that one more time. Whatever, just have to ignore that. Okay, so tenant leases property from landlord for 12 months at a rate of what? Let's say $1,000 a month, okay? After 6 months, they basically bail out, right? So 6 months in, T out, right? right? At 9 months, T2 comes in. Okay? And T2, we're gonna do a couple different hypotheticals here, okay? Hypothetical 1, T2 comes in and pays $800. Hypothetical 2, they come in and they pay $1,000. Hypothetical 3, they're paying $1,200. Is tenant 1, is T, liable for any loss of rental income following the end of the term of their lease, of their original lease? Can we all agree on that? They are not responsible for that, right? They contracted here to here. So let's say this is down to 18 months. None of this is T1's responsibility. So we've now narrowed the scope to the 12 months that they actually contracted for, right? So they bail out for whatever reason. Does landlord have to immediately go after tenant? No.
You need to mitigate the damages.
In every state? Or is that a split of authority?
It's split of authority.
Good guess, considering that I said that, right? Okay, it's actually a split authority on that, right? But the majority of states and jurisdictions will say, you have to do something to try and mitigate your damage. Does everybody understand what mitigation of damage means? It's okay, it's kind of a fancy word for basically saying, do something to help yourself out. Don't just keep bleeding money. Try and get somebody in there, right? Now, is it reasonable that it might have taken 3 months for them to get somebody new in there? Yeah. So, let me ask you this. They've paid, this is all paid, okay? Timely payment. Then we've got a couple of different hypotheticals, right? So, during the time between the 6-month and the 9-month mark, what are they responsible for? Tenant 1. $3,000, right? Is that a reasonable period of time that it could have taken for them to relet? Potentially, but what are you gonna look at? It's gonna be factually driven. Did the landlord just sit there and let it sit vacant and put it up a couple weeks before somebody rented it? If they did, then wouldn't you say, look, all they had to do was post something, this is a hot area, they could have gotten somebody to rent it for $1,000 if they had done something, because look at the facts. Within 2 weeks of them putting it on some rental site, it was rented. So they could have done that before, so let's try and minimize what I have to pay because they really just kind of sat around and did nothing, right? Now in a minority of jurisdictions, they can't. They could let it ride out for the next 6 months and go after that tenant 1 for $6,000 of damages. Now, it's not really fair to do that, right? Or is it? If I'm the landlord, I contracted for 12 months. I deserve the benefit of my bargain, right? Now we're going back to contract theory. The tenant is saying, look, I had to go. Let's use this example. Boyfriend and girlfriend, right? I see this all the time. They get into a fight, they can't live together anymore. They can't afford to live there with one party because they were both paying for it, right? So boyfriend says, hey, I gotta leave. I can't stay here anymore because I can't pay for this on my own. She and I had an agreement. She beat me up. I don't want her living anymore. So I got a restraining order and she had to move out. But we're both on the lease. I gotta break the lease. I gotta go. I gotta go move back with mom and dad or go move in with whatever, with some other roommate because I cannot afford to live here. Very practical situation. It happens. Sometimes it's not economically efficient to stay there. So at this point now, if we say they've done their due diligence, they put in ads out, in a couple of places online, put up those little things, you always see the piece of paper with the cut up pieces at the bottom and they, hey, you want to rent a room, pull this tab and call the number. They've done all that stuff. They've done everything they can to try and get somebody in, but it took 3 months to get somebody there. T1's going to be responsible for at least $3,000. Now, let's go through the different hypotheticals. If T1 is now responsible for $3,000 here, what are they responsible for here? Hypothetical 1, tenant 2 rents, so landlord relets the property, but at a rate of $800 a month because that's the best they can get at that point for that property. What does landlord now recover in addition to the $3,000 from tenant 1? $600, okay? Landlord relets for $1,000. What do they recover from tenant 1 in addition to the $3,000? Nothing, because they were made whole, right? Now, maybe things are looking up and now they have rented for $1,200. Well, depending on how you're doing the math, the immediate response would be they get nothing, right? My argument, if I'm representing tenant, is this should really be $2,400 now because they got an extra $600 over there, right? No?
Well, all the work you've had to put in as landlord, you put the landlord in a difficult position now. Now he's actually putting his own labor and trying to find someone else, so you have to put a price on that as well. And in addition to maybe painting and whatever he had to do.
That's probably going to be pretty nominal though. But I do agree, you could take, what if you had to pay for the ads? So let's say all of that came out to a couple $100. I'm still going to argue that I should only have to pay $2,600, right? This is for the effort and the ads. Wouldn't you make that argument if you were the landlord? Yeah, because what are you looking at? Because let's go back to the original theory is, I contracted for 12 months. I deserve the benefit of my bargain of the $12,000. Starting with 12 minus 6 is 6, right? Now, what did we recover for the balance of the 6 months? Well, we got $3,600. So minus $3,600 is going to be $2,400. That's what you're entitled to. Wait, I had some costs and expenses as a result of this. Okay, well that's about $200. That seems reasonable. Okay, maybe $2,600 again. Right?
I still don't think I don't think the tenant deserves anything because he's broke the lease.
Right, but they're not out $6,000. They're out $5,400. Right?
Yeah.
You don't get to get what you contracted for plus extra and then still go after the first guy. Make sense?
Yeah.
You deserve the benefit of your bargain, but so does the tenant. Right? Okay. Everybody get those concepts? Okay. That's about as much math as you're going to do in real property. I know, I'm sorry.
Just out of curiosity, would the court allow the landlord to come out ahead?
Yeah.
Like they showed that.
So what if they got somebody in there the next month
Yeah,
and
it's like-
they charged them more and they came out ahead? Yeah, but then what will be the point of suing? You didn't lose anything.
Yeah.
You have to have damages, don't you? That's the whole point of this. If you came out ahead, what loss have you suffered that you need to recover from that tenant? That tenant was very, very lucky. Right?
Okay.
Yeah, you don't get to relet it for more and then say you still owe me on the previous lease, because could you reasonably have two people living in there and paying you for the same property? No. Good question though. All right. So, let's talk about this a little bit more. Just as a general concept, tenant's duty to pay rent. What's the first thing you're gonna look at in the fact pattern?
Along the lease term,
Before that?
is there, right?
How much
Well, I mean, I get, you're gonna make sure it's a valid lease, right?
how much they're paying?
No? Are they still living there? I stopped paying rent, did I bail out, or am I sitting there and just not paying you? Okay, so let's talk about what happens if landlord finds out tenant stops paying rent because you have an independent duty to pay rent, right? By the way, if something's not working out for you and the landlord has breached something, does that mean you can stop paying rent? No, continue to pay rent. It's an independent obligation, okay? Now, there's some little exceptions where you can withhold certain things in some jurisdictions, but let's just say general concept is, even if landlord's mucking up, you keep your side of the street clean and you pay your rent, okay? So, tenant breaches this duty and is in possession of the premises. Landlord's only options are to evict through the court or continue with the relationship and sue for the rent due. Okay, I can either try and get you out because you're not paying, or I can sue you for the money you owe me. If the landlord moves to evict, she is nonetheless entitled to the rent from the tenant until the tenant, who is now a tenant at sufferance, vacates. What does that mean? If you stop paying me rent in September, but I have to go through the eviction process and you're not kicked out until November 1st, do I now just lose September and October's rents? No, I should be awarded that because you continue to live there. And I'm not your mom or dad. I don't have an obligation to allow you to live here rent-free. This is a business, right? I still had to pay my mortgage even though I was renting to you. So now I had to come out of pocket, not only not be paid for your use of the property, but I had to pay to make sure that I keep the property up to date. Right? Landlord must not engage in self-help. Don't change the locks. No forcibly removing people, right? You can't go and do the thing they do at bars where they grab your bed back of the shirt and flip you out the door. No removing tenants' possessions. You cannot go into the tenant's property, even if they are not paying you rent while they are at work, pack up all their stuff and put it out on the curb, right? Because what's going to happen there? You're going to get sued for anything they lose. And then you're probably going to be stuck with them, okay? So, those are the options if the tenant is still on the premises. Basic concept, you either evict them or you sue them for the rental value, okay? Now, if the tenant has left, there are different ways that they cannot be in possession. There are three. They surrender the property, they ignore, or they relet. Let's talk about those. The surrender. Landlord can choose to treat tenant's abandonment as an implicit offer of surrender which landlord accepts. Tenant shows by words or actions that she or he wants to give up the lease. If the unexpired term is greater than 1 year, what do you think the surrender has to be in? Right, why? Satisfy the statute of frauds. Okay, if this is a 5-year lease and after 3 years you decide to leave, you must surrender in writing to satisfy the statute of frauds, okay? The next option is they can just ignore. Landlord can ignore the abandonment and hold tenant responsible for the unpaid rent just as if tenant was living there. This is only available in a minority of states, right? So this is the split decision. This is the split of authority. that's not the one you're probably gonna get, but you need to know that and make that distinction. Some states will allow for the landlord to just act as if the person is still there and obligate them to their rental value. The other option, and the majority of states, they require them to relet the property or make efforts to do so. Landlord may relet the premises on the wrongdoer's tenant's behalf and hold him or her liable for any deficiency. That's what we did there. That was hypothetical 1, along with months 6 through 9 in the hypothetical we did. So it's based on a mitigation principle. The majority of states are saying, do something to help yourself out. You can't just say, woe is me, do nothing, and then think that you should collect from the other people. Now, what's the contra argument to that? I deserve the benefit of my bargain. I signed a lease with this person. I shouldn't have to do anything else. I already did the work. I found the person, we signed the contract, I was holding up my end. Why should I have to do anything? That's the theory behind the minority of jurisdictions rule for ignoring it, right? Okay. Okay, so let's go to our next case here. We just did Bank of Oregon, right? Yes. Okay. Transfers.
Fun stuff.
Every time I think of this, like assignments and subleases, I think of, anybody watch Friends? Right? Because they actually get a show that everybody's seen. Oh, wait, you're killing me.
I see it, I just don't watch it.
Okay, well, let me just say this. In the last episode, they all go put their keys up on the counter because at one point or one time or another, every single one of the people that's on the show has lived in Monica's apartment, which was her grandmother's apartment, and then it was sublet to her from the grandmother and the whole thing. So this, I always think of that when I think of assignments and subleases and how many of them might have been legal because it was a rent-controlled apartment. They didn't really want them to know that the grandmother wasn't there anymore, or aunt, or whoever it was, because they wanted to keep the apartment, right? Okay, go ahead.
This is Jacob versus Miller, it's 1951, Supreme Court of Arkansas. The facts are that in 1945, Jacob rented a building from its owner for a 5-year period beginning in March of 1946. The lease ends March 1st, 1951, and the rent was $200 a month. The lease stated it would terminate if the premises were destroyed by fire. Jaber rented the space as a rug shop until 1949 when he sublet the lease to Norbert and Son. Norbert and Son paid $700 for the assignment with 5 promissory notes. Norbert then transfers the lease to Miller, but 3 months before the lease ends, the building burns down. So Miller sues to obtain cancellation of the 14 promissory notes held by the appellant Jaber. Miller argued that it's a sublease, and therefore the lease ends when the lease ends, which in this case would be each of the 5. The issue is the instrument of the transfer an assignment or a sublease. So the first court ruled in favor of Miller using the common law English rule distinguishing the sublease from rental, which is if the instrument transfers the lessee's estate for the entire remainder to the term, it's an assignment. If it's for less, it's a sublease. So that's what the first court did, but the appellate court ruled that the parties intended the transfer as an assignment, not a sublease. All the language in the contract indicates that it's an assignment. The consideration was stated to be in payment for the lease and not in satisfaction of a tenant's debt to his landlord. The deferred payments are evidenced by promissory notes, which are not ordinarily given by one making a lease. Unfortunately, the assignment made no provision for the contingency of a fire, so Miller loses in a reversal.
Okay, so the general concept is an assignment is
For the whole term.
so all of the rights and obligations of tenant or landlord but most often tenant to tenant two are being transferred. If you are giving anything less than all rights and obligations of tenant one to tenant two, it's a sublease, right? You're either assigning all the rights and obligation, or it is something that is right? Less than to tenant two. So you can sit, thank you. Assignments and subleases. In the absence of some prohibition in the lease, tenant may freely transfer his or her interest in whole, thereby accomplishing an assignment, or in part, thereby accomplishing a sublease. In the lease, landlord can prohibit the tenant from assigning or subletting without landlord's prior written approval. Why is that? So let me just say, as a practical matter, has anybody ever rented an apartment?
Yeah.
Okay. Did you have to fill out an application?
When I got on the lease, I used to sublease.
East Coast people, okay. No, I'm just kidding. Okay, so generally speaking, you have to fill out an application, right? Why? Because they want to make sure you're an appropriate candidate to rent to, right? Credit check. Maybe a criminal records check, right?
Better be a soft credit check.
So they want to do these things to make sure that you're an appropriate candidate. I don't want to rent to somebody that's had 5 bankruptcies and, you know, has a bunch of judgments against them for non-payment of rent to previous landlords. Do I? No, I don't want to do that. So I want to make sure that they're good people, that they've done what they need to do, that they're keeping up with their obligations. I'm not saying the people that can't pay their bills aren't good people. I'm just saying it would be unfortunate to be surprised by something like that. Or if I have a home that is a family community, do I want to rent to somebody that is a registered sex offender? Probably not. I mean, then we go back to that other case, you know, is it foreseeable that this guy who committed acts against 10 different underage kids is now a liability to your building where there's a bunch of little kids running around, right? Okay. So that being said, I want to know who I'm renting to. So if somebody goes and sublets or assigns their interest to somebody else that I don't know, that I didn't contract with, why should I have to rent to them? Right? But if the lease is silent on that, can you do it? Yeah. What happens if now we're 3 people removed? Well, I assign to you, you assign to Daniel, Daniel assigns to everybody over on this other side of the room. Oops. Who am I renting to? Right? I don't know. 6 degrees of separation at this point. I have not a clue, right? It could be anybody. So, huh?
It has to be Kevin Bacon.
I was gonna throw out Kevin Bacon, and then I was like, oh my gosh, nobody watches Friends. So Kevin Bacon is.
Seinfeld is better.
I mean, I'm not saying that Seinfeld's not good, but we did just have a conversation at lunch too about the guy who wanted to be called the Maestro, and we're like, no, not happening. Okay, so that being said, we now have somebody who you have not agreed to contract with that owes you rent. And I'm not really in privity of contract with that person, am I? If it's a sublease, am I in privity in contract with the sublessor or sublessee? No. They owe a duty to the person that they sublet from. I still have an agreement with the person that I contracted with, right? So, interesting. So that's how this works. We say landlord, tenant are in privity of contract, right? Now, tenant 2, no such privity of contract, right? They didn't contract with them. They contracted with this person. So if I'm not getting paid my rent, who do I get to go after? T, I'm gonna go after them. And who are they gonna go after? T2. Right? Do I have to go after somebody I don't know? No. Would I maybe list them as a defendant anyway, just to cover my behind? Maybe. You're the one that's living there. Oh, but what obligation do I have to you? I didn't make an agreement with you. I'm only paying $800 to the guy that I leased it from, right? So, in the lease, landlord can prohibit tenant from assigning or subletting without landlord's prior written approval. Now, always make sure that language is in there if you're a landlord, right? Because if they go and do that, that could effectively breach the terms of the lease, right? Now, if it says without express written notice and T decides to rent to T2 and brings that proposal, decides to assign to T2 and brings that proposal to landlord does the credit check and says, yeah, that seems fair, I'll give you the slide, you take off, this person's gonna take the obligation. And then T2 mucks it up. Does landlord have, well, no, let me use a different hypothetical. Okay, so T2 then says, now I'm going to assign to T3. Can they do that? If landlord has already given the okay for an assignment before. Unless
There is no consent from the landlord to do so.
Unless the.
do you need the consent of the landlord to do so at that point?
If he's given consent for one assignment,
Mm-hmm.
I don't think so. No, once he assigns it once, then you can assign it freely after.
Unless,
Unless it says every single time. Right?
okay, once landlord consents to one transfer by tenant, they waive the right to object to future transfers by that tenant unless it expressly reserves the right, right? So that's basically your way of saying, I get to have management over who is going to be my tenant. So there are two different terms that we're going to use. Privity of contract and privity of estate, right? So they're in privity of contract, privity of estate when you're here, okay? Now, if this person now takes over and it is done without the consent of landlord, these people might still be in privity of contract, but they're not in privity of estate because this person is not actually residing there, right? Now, they may have some privity of estate, but not privity of contract. But tenant one is still going to be secondarily liable in that case. So landlord and tenant two are not in privity of contract unless T2 assumed all promises in the original lease. Landlord and tenant one are no longer in privity of estate, however, they remain in privity of contract, right? Landlord and tenant one are secondarily liable to each other because of the privity of contract. Sublease, landlord and sublessee are in neither privity of contract nor privity of estate. Why? Because they're getting something less than the tenant is. Tenant is still basically on the hook for everything. They're the go-between that has to get their payment from tenant two, then they make good with landlord. That relationship doesn't change on a sublease, okay? All right. So I think that covers us there. Everybody kind of understand the distinctions there? You almost have to map these out, which is why I start drawing them. we start getting into a lot of pictures in our cases, okay? We only have 2 more cases for tonight, so would anybody object to just going through the last 2 cases, having a little chat, and then we can kind of get you guys out of here, which is not going to be common, okay? Any objections? Hearing none? Okay. I thought I heard something.
No.
She's like, no, I say no.
I
Okay,
said nothing.
so let's talk about Childs versus Warner Brothers Southern Theaters.
I'll do that.
Yes, ma'am.
Brian's.
I recall.
I don't recall, I have no independent recollection of that threat. We had a great investigator for like 100 years that his whole thing when he didn't remember something was never, oh, I don't remember, or I'm not sure. I have no independent recollection of that. It cracked me up because I could just hear him on the stand saying, I have no independent recollection of that event or that circumstance or something to that effect. It cracked me up. I'm sorry. Anyway, go ahead.
Okay, this is Child versus Warner Brothers Southern Theaters. So, this is a 1931 case, so I have here as a fact, says prior to 2/1/1923. I almost have to just do it in my head.
Well, just draw the picture.
I know.
You're welcome to.
So it says, the Berkeley Company owned certain property in the city of Columbia. The property was used for purposes of conducting a moving picture theater. So, on February 1st, 23, the Berkeley Company leased the property to R.D. Craver for 5 years, beginning 2/1/23 and ending 1/31/28. So around June 10th, 1925, Craver transferred and assigned the lease to Warner Brothers Southern Theaters. The transfer or assignment by Craver is to convey all right, title, and interest of the undersigned in the said lease. So Warner Brothers took charge and occupied the property until January 28th, 1926. So Warner Brothers then reassigns the lease to Carolina Theater. And Warner Brothers paid all the rent until they reassigned the lease to Carolina Theater. So plaintiff was notified by the assignment and notified Warner Brothers that Carolina Theaters can pay Childs directly, but Warner Brothers would still be recognized as the lessee. So,
So let me ask you this, is this an assignment or a sublease?
this is that would be an assignment, wouldn't it? No, because it's the assignment.
Was it all of their rights and obligations or something less?
Oh, so it would be a sublease then.
And what was our rule on sublease?
I don't remember.
Well, let me draw it for you and then you tell me.
Okay. So we had privity of contract. Privity of estate.
So, T2 breaches, right?
Right.
So they're gonna try and go after T2. And then if they don't get what they need from T2, who is secondarily liable in a sublease?
Then it would be
Here,
Right.
okay? In an assignment, you basically transferred everything to T2, so T2 is on the hook for it all. In a sublease, because it is something less than what T has, you're gonna go after T2, but you're gonna have T1
Okay,
secondarily liable. Make sense?
right, okay. So that's what they put on there.
Think about it, you're gonna go after anybody you can, right?
Right.
If T2 blows it, I still wanna go after T1 if they're still somehow involved.
That's why they put that Warner Brothers would still be recognized as the lessee.
Mhm.
Okay, I see. So,
So we kind of went rule first in our discussion and then
right.
case example.
So then this one, the rent accrued and there was unpaid, or of course, somebody wasn't paid, so. So I have here that, so the trial judge, based the judgment on the original lease. They looked at the original lease between Berkeley and, R.D. Craver. So, and they found that, let's see, and the judgment was for the plaintiff and the defendant appealed. So they have here that, I have here as the issue is if the lessor consents to an assignment of the lease, can such assignee subsequently make a valid reassignment of the lease without the consent of the lessor? I have to say that in my head.
Say it one more time.
So if the lessor consents to an assignment of the lease, can such assignee subsequently make a valid reassignment of the lease without the consent of the lessor?
We went over that rule. Let's look at it. They're gonna look very similar. Okay? Landlord, tenant. Landlord consents to tenant 2, right? So now we've got these two. What was the rule about waiver? If they agreed to do it once, can it happen again?
Oh, that's right. So yes.
Unless,
What was the
well, think back to the lease.
language? Unless it expressly reserves the right.
Right.
Okay.
So if they say, I'm gonna agree to this one, but each time you guys want to make a reassignment, you have to have my approval. If they don't do that, then it can be done. Additionally, if the lease does not speak on assignments, they could, in theory, assign it to somebody else.
Okay.
I'm gonna say most leases probably include a you cannot assign without authorization of the landlord. And each assignment thereafter must be with the authorization of the landlord, as long as it's expressly stated in the contract or the lease. Okay?
Okay.
All right. We're getting close. All right. Then we'll do a practice exam when we're done. No, I'm just kidding. That was so mean, right? I wouldn't do that to you guys. Not tonight. Not again. Okay. So I love when people say not yet, because there was a great resisting arrest case that some friends of mine had, and the guy is like out of his mind, just belligerent, and then like threatens the cop and his family and the judge. There's like no judge assigned to the case yet, right? And he's like, did you just threaten to, whatever it was, like threaten my family's life? And then the guy just turns around and goes, not yet. Oh, with like a heavy accent, but it was just beautiful.
Oh.
So, okay, 21 Merchants Row Corporation versus Merchants Row Corporation.
I'll do it.
Mm-hmm.
I think 21 Merchants Row Court sounds like a game.
Just sounds very British.
All right, so the plaintiff, 21 Merchants Row Corp., entered into a lease with defendant Merchant Row Inc.'s predecessor in 1974. The lease included a provision that stated the tenant could not assign the lease or sublet in whole or in part without having received express written consent of the landlord. Defendant acquired the premises in 1983, and then in the summer of 1987, the plaintiff entered into a purchase agreement for the sale of the plaintiff's business. The sale was contingent upon the defendant consenting to an assignment of the plaintiff's lease. The defendant fought it, but finally consented in writing to the assignment of the lease to the buyer, but specifically stated that it was not waiving its rights regarding any future assignments of the lease. The buyer and the plaintiff then requested that the defendant consent to the assignment to the bank through which the buyer was financing the purchase. And then that assignment would give the bank the absolute right to further assign the lease without obtaining the landlord's consent.
Oh, sure, why not?
And the defendant wasn't having it, and it didn't want to lose control of the its property and refused to consent to the assignment to the bank. So then the plaintiff brought the action arguing that the defendant unreasonably withheld its consent to the assignment of the lease. So the issue is whether in a commercial lease, the requirement that the tenant must obtain the landlord's consent before signing the lease implies as a matter of law that an obligation on the landlord's part to act reasonably in withholding consent. The rule is on page 556. A lease provision requiring the landlord's consent to an assignment or sublease permits the landlord to refuse arbitrarily or unreasonably. And the court says that they see no sound reason to depart from this rule and to grant greater protection in this regard to commercial tenants than what's afforded to residential tenants. This court and other jurisdictions see no rational distinction between residential and commercial leases in this regard. Since the bargaining power of commercial tenants at the drafting phase is ordinarily greater than that of residential tenants, if the court were to differentiate between the two types of leases, the court would do so in favor of residential rather than commercial tenants. Thus, the court says it's a matter of public policy and they don't want to give more protection to commercial tenants than would be offered to residential tenants in the same situation. It's pretty much they ruled already in that this would apply to residential tenants, so they don't want to offer more protection to commercial tenants. So the holding was that a landlord is not obligated to act reasonably, and they can withhold consent if they want to.
Well, I mean, I suppose you ask what's reasonable, right?
Yeah.
I can basically say, no, I contracted with you. You don't like it, you shouldn't have contracted here. But maybe it's a restaurant. Maybe the restaurant is selling to a new owner because the previous owner is just kind of ready to retire. And now the landlord's saying, nope, not if you want to be in this spot. Right?
Yeah, here I think it was just the second assignment. I think he had it after the first one
Mhm.
because he was fighting on the first one. He didn't want to do it, but he expressly said, I don't want to waive his right regarding any future assignments.
I wouldn't.
So,
I want to know who I'm leasing to.
right.
Seems reasonable.
Mhm.
Don't have to have any particular reason why I don't want you here, I just don't.
I think if it was on the first assignment and not to the assignment to the bank, it would have been less reasonable.
Not just that, because as a private landlord, do I now want to go up against a bank or a corporation that has corporate counsel and other things and unlimited resources if we have some kind of dispute? Nope. Might be something to consider, right? Okay. All right, the last page of your handout deals with the law of fixtures. I think we've discussed those previously when we've talked about waste. So I just want you guys to review that. Security deposits are typically statutory, so just be mindful of that as well. I don't think there's really any long discussion that needs to occur on that. If you have any questions, you're welcome to ask those now. Going once, going twice. Hearing no interest in staying longer, I will let you guys have a lovely evening and see you next week. You're almost halfway through real property. I'm sorry. Have a happy Thanksgiving. Careful with that turkey.
Oh, that's right.
It does make it fall.
The tryptophan can make you a little tired.
I thought you were saying because it was salmonella, I think.
Oh, I got a clue. No, I'll eat that anyway. No. I want to be careful with the tryptophan. To be fair though, you do have to eat an awful lot of turkey. Like people are like, oh, the tryptophan, it makes me tired. I'm like, no, you ate a S ton of carbohydrates and a lot of sugar and then got amped out and then crashed and you had to sleep. You have to eat a lot of turkey to get to the level of tryptophan that would really make you like narcoleptic.
That's not bad.
So
Yeah.
in any event, everybody please enjoy your holiday. It is my favorite holiday of the year. And
We should get to eat that, have that whole pie.
Oh my god, it's the whole pie, right?
I just bought 4.
I'm not gonna say that I only like one kind of pie, so it's cool though, I deserve it. I gave my parents 2 kids, or 2 grandchildren, at once. Oh my gosh, alright, I don't know if this turned off or what the deal is. I'm always a bit inept with this. No, not a clue. Okay,
Do you want our briefs?
hold on to them, and when Professor Drucker brings back the notebook the week after Thanksgiving, then you guys can pop them in there. That means if you forgot to put them together for any reason, I will still accept them in 2 weeks. All right. Happy early, well, you gotta come back tomorrow. Happy early evening, and you only have 1 more class before you get a week off. And when you come back, we get to talk about easements, which I love, and covenants and servitudes and all the good stuff for the rest of the semester. Enjoy.
Class is separate, right?
Yeah.
I don't know if you have class the following Saturday. You wanna double check on that, I don't think you do, because people are gonna be recovering from Thanksgiving and Black Friday.
I'm doing Black Friday.
Huh?
I'm doing Black Friday.
Are you?
I'll take this one.
More Christmas shopping.
Where you going?
I'm going to my buddies down by Six Flags. It's like aunt's house. And I don't know what's around there, honestly.
I went one year. Oh, it was last year. The Ontario one.
Yeah.
It was horrible. It was no place to sit. Oh, we weren't doing the shopping. That's different if you're doing shopping.
I'm only going for like electronic stuff. Like I'm getting my mom a Kindle. And
Nice.
yeah, it's other stuff. She needs a new Kindle.
See ya.
See you tomorrow.
How many? Last 3? Did you get the last 3?
No, I think the last 4, I only got 2 done.
I'm gonna do that tonight. Stay up and do.
I'm not, it's 5:30, I'm going to sleep. What time do you have to be at school?
Well, tomorrow I'm at West Shores, so I have to be there by 6:50 and like a 45-minute drive.
That's all.
Like, yeah, at 2. But I have to go with my brother. In my brother. So that's like an hour.
The deep right into the semester, like every morning when I wake up, I just always find myself saying, let's go.
Yeah.
Yeah, I just have to like keep myself in the mind frame. Or else I'm just gonna burn out.
Time for yogurt.
Yeah.
It's actually
That's
pretty
what
good.
sorry, you like yogurt?
Like frozen or regular yogurt?
Regular yogurt.
Yes.
Oh.
I like raspberry yogurt. I like strawberry too, but I like raspberry more.
My aunt got a yogurt maker, not a frozen yogurt maker, but a yogurt maker. And I find yogurt repulsive. I don't know why, I just don't like it. She spent money on a yogurt maker. A nice one too, it's like
Like, why do I need to reinvent the wheel? Tillamook makes like great raspberry Greek yogurt.
Does she have like a little garden with like fresh fruit?
no, she just loves
She
yogurt.
have cows, so she can just milk them and mix it all together and.
No, but it's like a nice fancy one, like the brand Cuisine Art or something, it's like stainless steel and all the rest of it.
Like yogurt maker.
A yogurt maker, I've never heard of it.
I mean, I know they make ice cream makers, but
Right.
it's not a frozen yogurt maker.
Yeah, I called her a weirdo. I was like, people have ice cream makers. I've never seen a yogurt maker. And plus, I just personally find it repulsive. I hate yogurt. so.
You've said that now 3 times, so I will.
A personal vendetta. I have a personal vendetta against yogurt.
It's like Dean Dolan's aversion to mayonnaise, sour cream, really anything,
Really?
tartar sauce, anything that is of the like kind.
Sour cream and mayonnaise is good. Alright.
My kids, if I let them, every day would eat a sour cream mustard sandwich. Don't ask me why.
Sour cream and mustard.
They just
I
think
can
that's
see
amazing.
mayo and mustard. I put mayo and mustard in every sandwich that I have.
No. The entire sandwich
It's
is
just sour.
bread, sour cream, and mustard.
Both of them?
They both would love that. Rowan likes cheese. Remy, for some reason, I don't know how he was my child. He doesn't like cheese now. And I'm like, you're a crazy person. You're a crazy person, Mommy. I eat meat.
He's a big boy now. He needs protein.
He weighs 5 pounds more than his brother.
Wow.
They're the same age.
They don't look.
They are built almost the same exact height. He weighs 5 pounds more. That's pretty significant given that they weigh like around 40 pounds.
Yeah.
You pick Remy's, he's built like Phil. He's built stocky and solid. And Rowan's just a little more like, okay. Yeah. And you can see Remy's got a bigger booty. Cracks me up. He's got that little like beefy body and
He's the one that likes cheese or doesn't like cheese?
doesn't. He eats meat.
He's me.
Sounds like a man.
Yeah.
Sounds like a boy you're talking about. Man.
Oh my god, I'm in so much trouble when they're like 15 and they're just like eating everything that's
That's
not
my
nailed
brother right
down.
now. He's 16 and he plays football.
Oh my god, constantly shoving stuff in his face, I'm sure.
Yeah.
Yeah.
He's like, you don't feed me enough. I'm like, I had 3 sandwiches.
Have you guys seen The Breakfast Club?
Yes.
Okay, so you know Andrew, the guy that's like the wrestler or whatever, when he opens up his big shopping bag and he's like 5 sandwiches, they're monster sandwiches. It's like a full thing of cookies, like 9 apples.
Typical high school jock.
Oh yeah. Whatever.
Right.
Yeah,
See you guys
cool.
later. I know. I'll see you guys. Have a great night. Happy Thanksgiving.
Close.
Yeah, you can leave it open.
Okay. Happy Thanksgiving.
You too.